Thank you. I want to thank Stephen Schragus and his team at One Day University for having me back. I love doing One Day University events. A friend of mine asked me, what's the biggest difference between teaching your undergrads and your One Day University students? And I said, well, at One Day University, if we schedule class before noon, people still show up. So I want to thank all of you for being here in New York, and I want to thank the more than 1,000 people all around the country who are tuning in for this live stream, the biggest live stream in the history of One Day University. And this is also an exciting day because my grandma Marilyn has come all the way from Delray Beach, Florida to be here with my mother. So today what I want to do is break up class into two halves. So I'll start off speaking for around maybe 50 minutes, and then we'll do 10 minutes of Q&A, and then we'll take a 10-minute break. And then we'll come back and I'll do another lecture session and we'll do another Q&A session. We're going to talk today about the most politically explosive parts of the US Constitution: church and state, gun rights, impeachment. And by going back to the original text of the Constitution and the words of the founders, we will find that many of our common assumptions are faulty, and many enduring myths need to be debunked. But before we start revealing the Constitution's hidden truths, I want to first dial the clock back to the summer of 1787 and the Constitutional Convention, its setting, its most heated debates, and its larger-than-life characters. As the delegates to the Constitutional Convention descended upon Philadelphia that summer, they encountered a city that was at once energetic yet tidy. A Scottish military officer praised the, quote, great and noble city of Philadelphia as one of the wonders of the world. A traveler from Germany was equally impressed. In his words, the city, if not greatly beyond others in wealth and number of houses, far surpasses them all in learning, in the arts, and in public spirit. And he wasn't wrong. Philadelphia at that time was home to numerous libraries, learned societies, publishing shops, and the University of Pennsylvania. Stretching west from the Delaware, Philadelphia had been laid out on a grid a century earlier by William Penn when he founded the colony. Streets that ran parallel to the Delaware River were numbered, 2nd Street, 3rd Street, 4th Street, and streets running perpendicular were typically given the names of trees like spruce, pine, and chestnut. Now, in the era of the Constitutional Convention, the delegates would have found the streets to have been generally kept tidy by the residents, although you could find the occasional cow or horse carcass rotting at a vacant lot. Delegates strolling down lamplit streets in Philadelphia in the evenings would have heard night watchmen calling out the time and the weather. Church bells were commonly rung in the city, often 13 times to honor the 13 states of the Union. One visitor remarked, "At Philadelphia there is always something to be chimed, so that it almost seems as if it were an imperial city." Houses lining the road were largely uniform, with red brick exterior and English-style decor within. A room would usually have a fireplace, and for those who could afford it, mahogany furniture. Behind every home was a garden or a courtyard. Benjamin Franklin in his courtyard had this lovely mulberry tree, and he would gather delegates for chatting under its shade. In the eyes of one observer, Philadelphians managed their homes with the ideal balance between the austerity of Amsterdam on the one hand and the pomposity of Paris on the other. In his words, "The taste generally is for living in a cleanly and orderly manner without the continual scrubbing of the Hollanders or the frippery and gold of the French." How newcomers experienced Philadelphia often said more about the origins of the visitor than they did about the local inhabitants. One delegate to the Constitutional Convention from the Virginia countryside found Philadelphia to be pretentious. He complained that he was, quote, heartily tired of the etiquette and nonsense so fashionable in this city. But a European traveler accustomed to the hierarchies of the old world found in Philadelphia a remarkable spirit of equality. He said, people think, act, and speak here precisely as it prompts them. The poorest day laborer on the banks of the Delaware holds it his right to advance his opinion in political as well as religious matters with as much freedom as the gentleman or the scholar. Now, to be sure, Philadelphia was not without its problems. Crime was a concern. Just a couple months before the Constitutional Convention, 18 convicts escaped from the local prison. And disease was a recurrent threat. The city had experienced bouts of yellow fever in the mid-century, and just a few years after the Constitutional Convention would have its worst epidemic yet. And for residents living near Philadelphia's dock, the odor was simply intolerable. They sent a petition to the General Assembly bemoaning, quote, the stench of mud and putrefying filth, which has rendered the dock a grievous nuisance, offensive to the senses, and dangerous and injurious to the health of the neighboring inhabitants. Now, at the time, it was commonly believed by medical practitioners and lay people alike that bad smells actually caused diseases. But if that were true, then none of us would have survived our subway rides this morning. The convention delegates lodged at Philadelphia's numerous taverns, which doubled as hotels where they could find food, lodging, and of course, drink. The Indian Queen Tavern was the preferred place for the wealthiest delegates. This was the Ritz-Carlton of its day. Upon entering its luxurious premises, your bags would be handled by a servant who was in full uniform with a ruffled shirt, a blue jacket, a red cape, and a powdered wig. And all of your needs would be met at the Indian Queen, whether your request was simple, like tea or magazines, or whether you had a more onerous request, like you wanted a barber brought to your room for a haircut. They would arrange that. The delegates also frequented the City Tavern, just a few blocks away. The City Tavern was not quite as elegant as the Indian Queen. A British antique dealer described having, quote, slept at this house 2 nights and met with my old tormentors, the bugs. While the bugs paid this Brit too much attention, the hotel staff paid him too little. He complained, we could hardly get any attendance from the waiters, though we rang the bell incessantly. Nevertheless, the City Tavern was a focal point for business in the city. It kept records of incoming and outgoing ships, and merchants frequented its coffee house daily. It was there at the City Tavern that the delegates to the convention were hold their farewell supper at the summer's end. Some delegates, like Alexander Hamilton, spent the summer boarding at Mrs. Daly's, which was at the intersection of 3rd Street and Market. Now, Daly's stood at the end of an open-air market where every Wednesday and Saturday, people would pour in from the countryside to hawk their wares and purchase their provisions for the week. And you could find cuts of meat unknown to European taste buds, like raccoon and possum. The Constitutional Convention was held here at the State House on Chestnut Street. It was there 11 years earlier that the Continental Congress signed the Declaration of Independence, and the building would, in time, come to be known as Independence Hall. The State House was elegant in its simplicity, as you can see. One contemporary wrote, the facade is of tiled brick, with no particular decoration, but in comparison, regular and handsome. The delegates had come to Philadelphia to salvage a country whose very existence was mired in doubt. The country at that time was operating under the Articles of Confederation, and the Articles were failing. Under the Articles, the 13 states were bound together only tenuously, and you needed unanimity to pass anything. And so one state effectively had veto power over the rest of the country. In 1781, 12 of the 13 states agreed to a 5% impost that would be paid directly to the federal government. But tiny Rhode Island unilaterally sank the measure. And I'll also mention that Rhode Island was the only state not to send delegates to the Constitutional Convention. And it also resisted ratifying the Constitution. It was the last state to finally give in to ratification. Rhode Island was sort of a problem child of early America. But for anyone who's viewing this live at home from Rhode Island, I say this from a place of love. I did a master's at Brown. I used to be a Rhode Islander. And we're thrilled to have you in the country. Its critics would actually refer to it as Rogue Island in the 18th century. Now, with respect to the Articles of Confederation, there was a legislative branch. We did have a Congress, but there was no executive branch to enforce laws, nor was there a judiciary that could arbitrate legal disputes between citizens of different states. And these structural problems compounded economic challenges then bedeviling the young republic. The British had cut off American merchants from lucrative trade with Britain's Caribbean colonies. And other European powers like the French, the Spanish, and the Portuguese refused to sign commercial treaties with America. They saw us as a trading rival to be bested. And so American farmers did not have foreign markets to send their produce. And as a result, American farmers lacked funds to buy goods from local merchants. And the local merchants who were oversupplied had to then dump their merchandise at prices that were too low for them to turn a profit. And so bankruptcy loomed for the soil tiller and shopkeeper alike. And compounding these challenges was the fact that America had no coherent national economic policy. The country was essentially 13 mini-nations. Congress had no power to levy taxes. It had no power to force states to abide by treaties that it brokered with foreign powers. Each state levied its own tariffs on goods coming in from other countries, and sometimes American states levied tariffs on each other's goods. Now, these economic and political problems fed into each other in a vicious cycle. In the 1780s, people entertained legitimate fears that America would, in its infancy, degenerate into civil war. In 1786, frustration gave way to violence in a bloody episode known as Shays' Rebellion. A Revolutionary War veteran named Daniel Shays put together a ragtag militia consisting of people who were upset that farmers who could not afford to pay off their debts were getting imprisoned. And the federal government proved totally ineffective at lending Massachusetts any help in maintaining the rule of law. Eventually, the creditors hired a mercenary army to put down Shays' Rebellion. But the episode threw into high relief the impotency of the central government. The American colonial experience had bred in Americans a mistrust of centralized power, but the pendulum had swung too far in the other direction. The government was too weak to function. George Washington was horrified by Shays' Rebellion. In his words, "I am mortified beyond expression that in the moment of our acknowledged independence we should, by our conduct, verify the predictions of our transatlantic foe and render ourselves ridiculous and contemptible in the eyes of all Europe." Now, I don't know if you can imagine in 2018 Europeans seeing Americans as ridiculous and contemptible, but try your best. Now, Washington's presence was vital to the success of the convention. No one else came close to rivaling Washington in the esteem he garnered from his fellow citizens. And his presence there as the chairman of the convention lent it credibility. And so for this reason, Washington can be thought of as symbolically the most important delegate. But in terms of the intellectual firepower of the convention, the real father of the Constitution was James Madison. He's a little bit older in this portrait, but Madison was only 36 at the time of the Constitutional Convention. And although he was one of the youngest delegates, he had the richest knowledge of any delegate of ancient Greece and ancient Rome. And for this reason, the other delegates often were reverential towards his knowledge base that he had to bear on statecraft. Now, James Madison, if you just saw him at first blush, you wouldn't necessarily think that he was a natural-born leader. He was very shy and retiring in temperament. He was 5'4" on a good day. And so people were surprised when they would meet his wife, Dolly Madison, who was beautiful, she was outgoing, she had a razor-sharp wit. But Dolly saw in James something not everyone else did. She understood that he was a gem. He was a prodigy. He had graduated Princeton in just 2 years. By his mid-20s, he had already been elected to the Virginia state legislature, although he lost his seat because he refused to rely on a common ploy of politicians in that day, which was to win over your constituents with free whiskey. And this at a time when the average American drank 3 gallons of whiskey annually. So James then went on to become a major figure in national politics, as we'll see. Now, among the other prominent delegates at the Constitutional Convention were Benjamin Franklin. He was, of course, the great Renaissance man of early America. Benjamin Franklin had been a pioneer in diplomacy, in science, in newspaper publishing, and in 1776 he had been the chairman of Pennsylvania's state constitutional convention. And as a Hamilton biographer, I'd be remiss if I didn't say a word about Alexander Hamilton, who at 32 was even younger than James Madison. Hamilton had a very different profile than the other founders. He had grown up in the West Indies. He was born on a British island in the Caribbean and raised partly on a Danish Caribbean island. He was attending King's College, or what we know today as Columbia, just a few miles from here. And war breaks out while he's an undergrad. And he ends up serving under George Washington. He becomes George Washington's aide-de-camp, effectively his chief of staff, and rides Washington's coattails to power. Now, some of the iconic figures of the era were not present. John Adams was not there. He was off in London serving as the ambassador to the British. Thomas Jefferson was in Paris serving in that same capacity to the French. But most of the people we think of as founding fathers were in the room at the Constitutional Convention. Now, the convention was closed to the public, and the delegates were sworn to keep the proceedings in the strictest secrecy. At least they were supposed to. Not all of them did. But the delegates understood that if they were under daily public scrutiny, it would be very difficult for them to hammer out the compromises that would be necessary to bring together the 13 states of the Union. And there were fierce disagreements among the delegates. And I'll mention just a few for you. One major point of contention was representation in Congress. Should states be represented based on their population, or should every state get equal votes? And naturally, a state like Virginia, which was 10 times the size of Delaware, had a different view on it from smaller states. And ultimately, the compromise they forged, which we have still today, is to have 2 houses in the legislature, where the lower house has proportional representation, and the upper house, every state gets 2 votes. Another point of contention was, how will slaves be counted for the purposes of congressional representation? So they had a compromise, a notorious compromise, wherein slaves would count as 3/5 of a person. And there was also debate about what the executive branch should look like. They are agreed there should be an executive, but should there be an executive who serves for life? Or should we have 2 presidents at the same time? They considered all of these options, and they eventually settled on having one president who would serve a 4-year term. Now, it's important to keep in mind that many of the important parts of the Constitution did not reflect the monolithic view of all of the delegates. Rather, they were compromises between competing visions. But for all the heated disagreements of the convention, don't let it obscure the fact that the delegates agreed on two major points. First, that the country needed a far more robust federal government to be effective. And secondly, they agreed on the value of individual liberty. So now that we have some historical context for the Constitution, let us turn to the task of debunking some of the false assumptions and enduring myths that cloud our collective understanding of this document. First, there's a lot of talk about how we have 3 co-equal branches of government. Well, the framers did create a system of checks and balances to ensure that no one branch would completely dominate the other 2. But there was never any intention of having 3 co-equal branches. Let's consider what the framers said in the Federalist Papers. Now, the Federalist Papers are the best-known primary sources from the ratification debates. Keep in mind that when the convention wrapped up its work in September of 1787, the Constitution had no legal force. It was just ink on parchment. Only if the states ratified the convention would it go into effect. And so every state debated whether or not to ratify the Constitution. And the Federalist Papers were an effort to try to persuade people here in New York specifically to ratify. And they were co-authored by Alexander Hamilton, James Madison, and John Jay. Now, they consisted of 85 essays, largely written over a frenetic 6-month period. And the authors wrote, for the most part, independently, but they shared a common pseudonym, which was Publius. Now, Publius was the name of a Roman statesman who had overthrown a monarch and established a republic in ancient Rome. So what do the Federalist Papers have to tell us about the balance of power between branches of government? James Madison, Federalist 51. In Republican government, the legislative authority necessarily predominates. So, it's hard to imagine a clearer statement that the branches of government are not equal. What about Alexander Hamilton, Federalist 78? He says the judiciary is beyond comparison the weakest of the 3 departments of power. Hamilton goes on to say, look, the president is the commander-in-chief. He controls the military. Congress has the power of the purse. They control the money. But the court has no means to enforce its decisions. So no one should really be too concerned about us establishing a Supreme Court. He says, don't worry about it. They just have to hope people abide by their rulings. Why would the framers want 3 unequal branches of government? Well, consider this. In colonial times, every colony had a legislature whose representatives were selected by the people. But they also had governors and judges who were selected by the crown. And so the colonial legislatures were an important check by the American colonists on royal authority. British colonial rule had primed Americans to see legislatures as uniquely representative of their needs. And I would argue that one of the most striking aspects of American constitutional and presidential history is the extraordinary growth of presidential powers over the last couple centuries, far beyond what the framers initially envisioned. Let's talk about another myth surrounding our Constitution. Because politicians of all stripes speak about the Constitution in such reverential tones, it is easy for us to mistakenly assume that the Constitution was widely embraced at its inception. It was not. It was extremely controversial. One of the most famous patriots of the day, Patrick Henry, disliked the Constitution even before the convention revealed its final product. He feared centralized authority. He knew the direction that the delegates would likely move in, and he refused to represent Virginia at the Constitutional Convention. He famously declared, "I smell a rat." Only if 9 of the 13 states ratified the Constitution would it go into effect. And even then, it would only be binding on those states that had ratified. Any states that failed to ratify would effectively become foreign countries. And so each state had a ratifying convention, and the debates there were intense, an intensity that underscores just how contentious the Constitution was. A movement of anti-federalists emerged that vigorously decried the Constitution and labored to prevent its ratification. The Anti-Federalists said, look, it's only been 4 years since we signed our peace treaty with Great Britain, and we need to give it more time. The principal fear of the Anti-Federalists was a strong central government that would encroach on individual liberty. In the Anti-Federalist nightmare, the president would rule like a king, the Senate would rule like a House of Lords, and this whole aristocratic arrangement would be protected by a standing army. In other words, the Anti-Federalists feared that having fought the revolution to free ourselves from British tyranny, we would then forsake that revolution by adopting a homegrown version of British rule. The ratification debate here in New York was especially divisive. Major figures in New York politics opposed the Constitution. Even the chair of the state ratifying convention was an Anti-Federalist. 2 of New York's 3 delegates to the Constitutional Convention in Philadelphia had walked out midsummer in disgust. But the 3rd delegate from New York in Philadelphia, Alexander Hamilton, emerged as the Constitution's greatest champion. And he was also a delegate at the New York State ratifying convention in Poughkeepsie, about 90 miles north of where we are now. And in Poughkeepsie, Hamilton spoke of the Constitution with such eloquence and passion that the people who saw him speak were moved to tears. So it's important to understand just how contentious the Constitution was. There was a 30-27 vote in New York, the closest of any state ratifying convention. Another common mistake people make about the Constitution is that they assume that the Bill of Rights was originally part of the Constitution, or that it came right on the heels of the Constitution. In fact, it did not. George Mason was the first to advocate a Bill of Rights in the closing days of the Constitutional Convention. And the delegates didn't want to have a Bill of Rights. They had spent too much time in Philadelphia already, and they were anxious to return home. And what the delegates had not anticipated in rejecting Mason's ideas was that the American people would want to see a Bill of Rights. Hamilton stood among those delegates who thought that by enumerating the rights in a Bill of Rights, it would wrongly imply that the government could encroach on rights that were not listed in a Bill of Rights. And so the Constitution was ratified with the understanding that a Bill of Rights would soon follow. And yet, hopes for a Bill of Rights soon dimmed. You needed 3/4 of the states to ratify, and under Patrick Henry's influence, Virginia, which had the tie-breaking vote on the question of the Bill of Rights, refused to ratify. But eventually, the Bill of Rights was ratified, and Virginia caved in 1791. Yet another myth about the Constitution is that the foundational liberties in the First Amendment, freedom of religion, freedom of speech, freedom of press, these liberties were put in the First Amendment because they are our preeminent liberties. They are our first and foremost liberties. Here are some book titles of some recent books that betoken this view of the First Amendment. The First Freedoms, Church and State in America. First Freedoms, The Beginning and End of Religious Liberty. The First Freedom, A History of Free Speech. The truth is that the First Amendment was actually the Third Amendment. And it only became the First Amendment because the first two amendments never got ratified. The original First Amendment had a formula for determining the size of congressional districts. And the original Second Amendment concerned when members of Congress could give themselves raises. And so the First Amendment the Third Amendment got bumped up to the First Amendment. It's just happenstance. Another myth is that the phrase separation of church and state appears in the text of the Constitution. It does not. Here's the actual text of the First Amendment. Congress shall make no law respecting an establishment of religion. So where did we get the phrase separation of church and state? Well, to understand that history, we have to talk about Thomas Jefferson. Right? Jefferson had grown up in colonial Virginia, where the Anglican Church was the official church. Tax dollars went to support the Anglican Church. And a lot of Virginians who were not Anglican were not particularly pleased that their money was supporting a sect they didn't belong to. Well, Jefferson was actually the consummate Anglican insider. He had been educated by Anglican priests. He had attended an Anglican church. He had served in the colonial Virginia House of Burgesses at a time when being an Anglican was an essential prerequisite. And yet, Jefferson actually opposes having an official state church, and he wants to disestablish the Anglican Church. At the age of 36, in 1779, Jefferson is elected governor of Virginia. And I'm only 33, so I have some time here. Now, Jefferson, in that same year, drafts a bill called the Virginia Statute for Religious Freedom. And this bill calls for the protection of the free exercise of faith and the disestablishment of the Anglican Church. Now, of all the things that Thomas Jefferson achieved in his life, he only wanted 3 on his tombstone. One was the founding of the University of Virginia. The second was his authorship of the Declaration of Independence. And the third wasn't getting elected president twice. It was his authorship of the Virginia Statute for Religious Freedom. He initially was not successful at getting it through the Virginia legislature, but in 1786, thanks to his friend, a young James Madison, they were able to successfully shepherd it through, and it became the law down in Virginia. But we should be wary of thinking that the religious views of Jefferson and Madison were indicative of their contemporaries. Jefferson grew deeply anti-clerical, so much so that in the presidential election of 1800, Alexander Hamilton accused him of being a, quote, atheist in religion and fanatic in politics. Now, Hamilton was wrong here. Jefferson was not an atheist, but he was an idiosyncratic thinker. He denied most of the miracles in the Bible, and he believed in the moral teachings of Jesus, but he denied that Jesus was the Son of God. In fact, he produced his own copy of the Bible with most of the supernatural occurrences taken out, and he retitled it, The Life and Morals of Jesus of Nazareth. Now, why am I taking pains to illustrate that Jefferson's religious views were so idiosyncratic? Why does it matter for understanding constitutional history? Well, to answer that question, I have to tell you the story of the so-called Mammoth cheese. On New Year's Day in 1802, Jefferson receives an enormous wheel of cheese. It's 17 feet in circumference. And on its crust are emblazoned the words, "Rebellion to tyrants is obedience to God." The following poem about the cheese appeared in a newspaper at the time. "But Muse, you'll not forget to squeeze a word about the Mammoth cheese. Such cheese no man before set face on. 'Tis bigger than Don Quixote's basin. Such cheese, my stars, 'twould make one swoon. To view, 'tis bigger than the moon. This cheese is surely honored more than ever any cheese before. to feel the weight and force, forsooth, and crash of presidential tooth. Ye maggots that dwell in the cheese, with horror how your limbs will freeze, how you will kick and squirm and claw beneath the Jeffersonian jaw. What does a giant wheel of cheese have to do with constitutional history? Everything. The cheese was a gift from a preacher who wanted to thank Jefferson for his support for religious freedom. The cheese was a symbol of toleration. And on the very day that Jefferson receives this cheese, he decides to finally respond to a letter from the Danbury Baptist Church that he had received months earlier. Now, the Danbury Baptists had written to Jefferson to complain that the government in Connecticut was encroaching on their religious freedom. And Jefferson, inspired by the mammoth cheese and all that it represented, finally wrote back in a letter that changed the course of our Constitution. He writes, "I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state." But was Jefferson representative of his era in this view when he claimed that the Establishment Clause separated church and state? Was he expressing a widely held belief in his day, or was he merely reading into the Constitution his own political preferences? After all, the phrase separation of church and state came from his own pen more than a decade after the First Amendment had been ratified. What did the founding generation really intend with the Establishment Clause? Well, Americans did widely agree that the Establishment Clause prohibited the federal government from recognizing any one denomination as an official state religion. There could be no national church, but there was no uniform opinion regarding any additional meaning that might be wrung from the amendment. Another approach to the Establishment Clause would say that government can support religion so long as it doesn't go so far as to create a national state church. And to find a proponent of this view, we need look no further than George Washington. George Washington embraced religious pluralism and thought that government and religion could have a mutually supportive relationship. For instance, in 1785, even before the Constitution existed, Washington articulated this view when he expressed his support for a legislative proposal in Virginia that would have allowed government dollars to go to fund churches, but only if those tax dollars came from members of those churches. Washington wrote, "I am not amongst the number of those who are so much alarmed at the thought of making people pay towards that which they profess, if of the denominations of Christians." And then here's the key phrase, "or declare themselves Jews, Mohammedans, or otherwise, and thereby obtain proper relief." Another major figure of the founding era who embraced the Washingtonian view was his right-hand man, Alexander Hamilton. In 1796, as Washington prepares to step down from the presidency, Washington asks Hamilton to draft what becomes Washington's famous farewell address. And Hamilton includes in this address a passage with Washington tweaks the language, but it really mainly comes from Hamilton. And scholars consider this to be one of the most important, if not the most important declaration regarding religion ever to come from the father of the country. And I want to give you Washington's language here. "Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness. And let us, with caution, indulge the supposition that morality can be maintained without religion. Reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle. This is a sentiment you would never hear advanced by the likes of Jefferson or Madison. Now, in the abstract, we might think that those who supported the separation of church and state would be the most sympathetic to religious minorities, and that those who wanted government and religion to have a mutually supportive relationship did so because they wanted to exploit the levers of government to privilege their preferred sect. But we should be careful about reading our modern-day politics onto a constitution that was crafted more than 200 years ago. And we have to try to understand it on its own terms. Consider the views of Jefferson and Hamilton. Hamilton, who did not favor separation, expressed in word and deed the greatest affinity for Jewish Americans. As a powerful columnist of Columbia, he helped put a Jew on the board of the college, the first time an American college ever had a Jewish trustee. As the visionary of America's financial future, he collaborated with Jewish merchants. As a lawyer, he defended the credibility of Jews in court. And if you're interested in learning more about Hamilton and his connections with Judaism, including my case, that he himself was born and raised Jewish, I have a one-day university event here in New York on October 27th. And for those viewers who are watching down in South Florida, we're doing the same event on December 9th, and Grandma Marilyn will be making an appearance there. So come on down, hear about the evidence of Hamilton's secret Judaism, and meet Grandma Marilyn. Now contrast Hamilton's philo-Semitism with Thomas Jefferson, the great champion of separation of church and state, who said that Quakers and Jews would never embrace American identity because they were nations within nations. In Jefferson's own words, each state constituted, and I'm quoting here, a homogeneous mass acting with one mind, one nation, foreign to the land they live in. Now, I know there are probably some viewers in Virginia who are bristling, so I promise I'm going to take Hamilton down a couple pegs in the second half of today's talk. Now, it's striking that in the 19th century, the people who embrace the Jeffersonian vision of a wall of separation are not those who favor religious minorities, but those who fear them. In the 1830s, 1840s, 1850s, as America industrializes, hordes of poor Catholic immigrants, they weren't all Catholic, but a lot of them were from Ireland, come into the country to work in our factories. And Protestants feared that these Catholic immigrants were the front lines of an invasion from the Pope. And people entertained delusions that America would become beholden to Catholic authority in Rome. And so they championed the separation of church and state as a way to keep Catholics in check. It's not until the 20th century that the separation of church and state becomes the secular ideal that we know today. Now, in 1947, in a famous Supreme Court case, Justice Hugo Black, writing for a majority on the court, takes Jefferson's language from this Danbury Baptist letter and equates it, conflates it with the Establishment Clause. And here's the actual language from the Supreme Court. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach. Jefferson mattered, not because his words to the Danbury Baptist Church were reflective of a consensus view of the founding era. They were not. They mattered because they, after the fact, lent legitimacy to the Supreme Court's preferred jurisprudence 150 years later. So am I saying that the Supreme Court should abandon decades of precedent separating church and state. Not necessarily. I hate to admit this as a Hamilton biographer, but I happen to think that Jefferson and Madison, there's some merit to their view. But we should be honest about the fact that there was a wide diversity in the founding era about just what the Establishment Clause meant. So I think what I want to do, because we're coming up towards 11 o'clock, is take some time for Q&A here before we move on. So does anyone have any questions about what we've discussed so far? Yes, sir.
Thank you. I'm a bit confused. The freedom of keeping religion away from the state was up to the Supreme Court decision, I'm gathering. Could a conservative court change that today, override?
So the question here is whether the Supreme Court, having said that the Establishment Clause means the separation of church and state, could the Supreme Court simply overrule that and find some other reading of the Establishment Clause? And for the record, if the Supreme Court were to say, well, the clear intent of the founding generation was for government dollars to go to churches, I would also say that was not a consensus view. So the Supreme Court has a couple different ways of dealing with precedents it doesn't like. Usually what they'll do is not just single-handedly overturn a precedent out of nowhere. They'll slowly chip away at a precedent, and they'll see what public reaction is. Right? The court is supposed to be above the partisan fray and insulated from the whims of the public, but the truth is it's not. And so if you look at Plessy versus Ferguson, right, famous Supreme Court case saying that that separate can be equal as far as racial segregation goes, right? A case from the 1890s. And then Brown versus Board of Education in 1954 overturns Plessy. But there's two things we should keep in mind about Brown versus Board, which said that separate is inherently unequal. First, it came as part of a succession of cases that had come before it, slowly chipping away at Plessy. And even when you have the Brown decision, it didn't desegregate everywhere. It only desegregated public schools. It was a pretty limited decision in a lot of ways. And so I don't think we would see the Supreme Court all of a sudden do away with the Everson case, but I think we'd see them chip away at it in different ways. And there are some modern examples of this where the court has said, well, you can't have a 10 Commandments inside of a courtroom because that would be a government establishment of religion. But if you have some kind of statue or memorial to the 10 Commandments and it's on the grounds of the Texas State Capitol, then actually that does seem constitutional. And so there are all of these gray areas. You know, we have "In God We Trust" on our money. You know, students say "Under God" in the pledge. There's all of these different examples around the edges where the court has some room for maneuver. So I don't think we'd see anything drastic overnight. But if a court wanted to move in that direction, it might be done in a gradual manner. Yes, sir, you.
There seems to be a new movement in First American jurisprudence that my religious rights individually cannot be offended by the government, whether it be I don't have to make a cake because it offends my rights, or I don't have to pay health insurance because it offends my religious rights. Do you see that anywhere in the historic development of the Constitution?
In terms of people wanting to cabin in the government because they say it's encroaching on my rights?
My individual rights.
Yeah, I mean, I think that there's...
Can you repeat the question?
Oh, sure, yeah, absolutely. So, you know, the question is, the questioner observed that there are many people today saying, well, as the employer of a company, if I'm forced to give this kind of health care to my employee, then that's violating my individual religious rights. There may be other kinds of religious rights that people feel are being encroached upon. Are there examples of that? I think there is a long tradition in American history dating back to the dawn of the Republic of people couching things in religious terms. and seeing many of their rights through a religious prism. In fact, at the time of the founding, it was common to read the Bible as a constitutional text and think about their rights as divinely inspired, right? Thomas Jefferson says we are endowed by our Creator with certain inalienable rights. So I think that in the founding era, perhaps even more so than today, people would have thought it would have been difficult for many people to think about having any rights outside of a religious context, because they said the government is merely recognizing rights that God has given me. And so we do see people making these kinds of arguments and often decrying. I mean, in the Danbury Baptist letter, what the Baptists were upset about was the fact that the Connecticut state government still had an established church and was supporting Congregationalism. And they said, well, that's violating our rights.
Our rights.
Yeah.
The point rather than my rights. The individual is what I was looking at.
Just one question, please. Any other questions?
Oh, sure. Yes, you, sir, in the corner.
Going back just historically, if Virginia had established Anglicanism as the state church and was accepting money from Anglicans to support the church, was all of the money they were accepting going strictly to the Anglican church in Virginia, or was some of it used for public good?
So tax dollars were used for a variety of things, but the only church that got money was the Anglican Church, and even non-Anglicans' tax dollars were going to support the Anglican Church. Sorry, the question was, and I'll just repeat it, I forgot, is in colonial Virginia, were tax dollars strictly going just to support the Anglican Church? And you know, when Virginia was first founded, it was much more heavily Anglican, and Virginia becomes more religiously diverse over the course of its colonial history. And so we see this kind of agitation and resentment towards people paying towards a religious profession that they themselves don't belong to. Other questions? You, ma'am, right there.
It's true, I believe, that most of the writers of the Constitution were religious in one way or the other. However, there's not a word about religion of God, actually, in the Constitution. That speaks for itself, I think.
So the question was, or really a comment, I guess, is that the founders don't discuss religion in the Constitution, that they don't discuss God in the Constitution. And actually, George Washington receives a letter from a group of ministers who says, you know, you wrote this Constitution, where's all the religious language? There is some religious language that we are going to discuss in the second half today. Two clauses. One is that there's a ban on religious tests for public office. And the second mention of religion comes in the First Amendment, which is the Establishment Clause and the Free Exercise Clause. Now, there's a story about Hamilton that is not verifiable, but has sort of floated around after his death, that he was asked after the Constitution why they didn't mention God, and allegedly Hamilton said, "We forgot." But it may be apocryphal, but it speaks to a larger kind of disengagement that Hamilton had from organized Christianity. Yes, right here.
Can there be a case made for rewriting the Constitution, considering how it was established in another time, in another world almost? And I know that there's been constitutional conventions every 20 years, but there's this argument that it's become political and the potential for dark money to infiltrate. So where are we with potentially making it more timely for our times?
Right, so the question is, could we have a new constitutional convention to draft a constitution to serve our modern day purposes, and notwithstanding the fact that the existing constitution has an amendment process, should we still feel beholden to that constitution? Well, people have been calling for a second constitutional convention ever since the first one ended, okay? Patrick Henry wanted to completely scrap the Constitution, and because we know there wasn't another constitutional convention, because we know the Constitution still is with us today, it's easy to overlook the fact that people had good reason to think, oh, we'll just call a new constitutional convention and scrap this one, right? Jefferson said, we could have one every generation. And so there's always been this idea that we could start anew. And it's a compelling question. And I think that I think it depends partly on how you prefer to interpret the Constitution. And so if you see the Constitution as a dynamic document whose original intent was to be read in a way that can accommodate the country to modern times, then there may be more flexibility built in. But ironically, it may be that someone who has a strict construction of the Constitution and interprets it in narrower terms may find it more difficult to adapt. But I think that the Constitution diehards would say, look, the Constitution's longevity is a testament to the fact that it's working. And that, I guess it's also a question about how much faith you have in today's modern day political leadership to improve upon the founders. And we haven't, we're in an era of political polarization where getting the necessary states to do that might be a challenge. But I think it's an interesting thought experiment, and you bring up a good point. How long are we going to go for?
Well, why don't we at least do another clause of the Constitution, and then we'll talk about if we're going to break.
Okay, that's fine. Okay, so we'll do another clause of the Constitution. Let's talk about now one of the most politically explosive parts of the Constitution, the Second Amendment. Here's the actual text of the Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, there are two ways of interpreting this amendment. There's the collective rights approach, which says that the amendment only pertains to those people who are serving in the militia. The individual rights approach says that this amendment gives all of us an individual right to gun ownership, regardless of any status in a militia. So, in 2008, in a Supreme Court case, D.C. versus Heller, famous or notorious, depending on your perspective, the Supreme Court ruled, and I'm quoting here, the Second Amendment conferred an individual right to keep and bear arms. Now, in this ruling, the Supreme Court invalidated a law in the District of Columbia banning handguns. So did the court get it right, or was this the case of a conservative majority cherry-picking historical evidence in support of its preferred politics? Now, there are actually really strong arguments on both sides. If we look at the history of gun ownership in England in early America, it tends to support the conservative majority. So if we go all the way back to the 5th century, when the Saxons invade England, they actually start requiring landowners to have guns. And then more than 1,000 years later, in the 1600s, Parliament starts to disarm political dissidents. And they pass legislation empowering the British government to do so. And there's a backlash against this. And Britain has the so-called Glorious Revolution in 1688. And one of the reactions to the Glorious Revolution is that Parliament, to appease the people, passes a Declaration of Rights that in many ways form the basis for the American Bill of Rights a century later. And the British Declaration of Rights expressly guarantees an individual right to bear arms. And even before the Glorious Revolution, we can see in early America a culture of individual gun ownership. In 1623, for instance, the Virginia colonial legislature passed a law requiring plantation owners to keep arms and ammunition at all times. So a supporter of the individual rights school can point to this long tradition of individual gun ownership in Anglo-American history. But those who support gun control can find a lot of historical evidence in their favor as well. Let's consider James Madison's original text of what was initially the Fourth Amendment, became the Second Amendment. The right of the people to keep and bear arms shall not be infringed. A well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. Now, the clause about religious scruples, this conscientious objector clause, was taken out at the request of Elbridge Gerry. And I'll mention as an aside that Gerry was a politician in Massachusetts who drew a district in the state of Massachusetts in such a convoluted fashion to favor his political party that his opponent said it looked like a salamander. And I have a map for you here. You can decide for yourself whether you think it's a salamander. But gerrymander is a portmanteau of gerry and salamander. That's how we get the term. But with respect to the Second Amendment, it could well be argued that Madison's language about religious scruples, about conscientious objecting, even though that particular clause was taken out, tells us something important. It tells us that the amendment has a military context. It has to be read with an understanding that it is referring to members of the militia. And let's go back to the final text of the Second Amendment and consider the comma placement, because I think this is actually really potentially revealing. Right? A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. Now, it's possible that in this awkwardly worded amendment, this clause, shall not be infringed, is actually referring to the first clause, a well-regulated militia, because otherwise you wouldn't need the comma separating arms and shall. Now, we can't be sure what the Committee of Style at the Constitutional Convention that worked out all these little sort of grammatical and punctuation details really meant, but it raises some interesting questions. And what's really interesting for me as a historian, what's so fascinating about the Second Amendment is how little controversy it engendered at its inception. Apparently, the people who drafted it and ratified it knew exactly what it meant because they didn't debate it at all. And as a consequence of the lack of debate, we don't have people who have actually written down and left for later generations some kind of primary sources to give us a really clear indication of what exactly they intended the Second Amendment to mean. It appears that, in a bizarre irony, precisely because there was so much consensus in its day, it created a lack of consensus later. So I think that, is Stephen around here? I think that so the next topic is sort of a big one. It's free exercise. So should we do our 10-minute break now, or?
Who thinks we should take about a 10-minute break? Okay. We're going to try and keep it right to 10 minutes, though, because we have a lot more. Then we'll ask some questions about this.
Okay, and then we'll do Q&A after the break.
Okay, so just a quick 10-minute break, maybe even less, and we'll get started.
Thank you. Is it on? Is this on? It is on? Okay. Earlier on, you talked about this sort of a linkage between the Bible, Word of God, Constitution, rule of law. But when I look at this amendment, I'm thinking of the whole notion of interpretation, amendment, and those sorts of things. When tell me what you think about the founders' view on how things would evolve over time. During that time, you had a musket ball, basically, a single-shot weapon. And now, over time, you have, multi-shot weapons and some pretty damaging ones. How would they have related to the notion of amendment and versus interpretation and precedent for guns, given that way that's worded?
Yeah, I mean, it's an interesting question. Should I repeat it, Stephen, or was that okay? So the question is, how might the framers have thought through, how an amendment like the Second Amendment should be interpreted, given that there's a big difference between, say, a musket ball and a machine gun or an Uzi? And so, it's in some ways it's a tough question because the framers, we sometimes forget this, but the framers had as little conception of their own immediate future, much less the distant future, as we have. You know, we're perennially shocked by current events. It was the same for them, right? We're all very impoverished at seeing even into next week, much less a century or 2 centuries later. And so I think the framers would have struggled to envision that. And I think that but with respect to your question, I think that different framers had different takes on this. And so I think someone like an Alexander Hamilton would have wanted wanted the text of the Constitution to be interpreted very broadly and adapted. And I think that other framers, like Madison, at least at certain points in his career, advocated a much more restrictive reading of the Constitution that might have struggled to adapt in the way that you've described. But the one thing I'll say specifically about the text of the Second Amendment is, if you see here, the key verb here is infringed. And there's a compelling argument to be made that infringe at the time was understood to mean not complete abolition of the right, but could encompass some regulation. And indeed, in the Heller case, the Supreme Court doesn't say, well, you can have a gun with no restrictions. It just says there's an individual right to gun ownership. And the government does have a hand to regulate it, although it's unclear just what regulations will pass constitutional muster. So thank you for your question. Yes, sir.
Yeah, I'm a little bit confused, I guess, because you started out talking about the Federalist Papers. And if you go back to Federalist Paper number 46, which was written by James Madison, who takes the first 8 paragraphs and explains the difference between central powers and the state. And the state, he constantly goes back and forth describing state as the people. The 9th paragraph, he says that excuse me, I had somebody talking in my ear back here. Yes, I'm going to nail it down right now. He says that the people in the state are one and the same, and the power of guns to be owned, they're in effect saying it's the state. I don't understand why our strict constructionists in Heller versus Washington didn't actually go back and read this kind of thing, because in effect they're going right to the horse's mouth.
Sure. Well, I guess, you know, one of the interesting things about the Federalist Papers is that they've been cited more in Supreme Court cases in the last 30 to 40 years than at any previous time in history, but they tend to be cited selectively. You know, one of the complaints that historians like me have about lawyers of all stripes, I don't mean to offend any lawyers here, but lawyers want a usable history. They want a history that's going to fit whatever their preferred argument is. And so we don't always get the kind of expansive look at all of the evidence, which is why I think it's so great that you tune in for a talk on constitutional history by a historian who's willing to consider all contradicting evidence without a pre-existing axe to grind. So thank you for your question.
One of the questions, or my question goes to understand this clause or this statement, I need to understand what the definition of a militia is and who you're protecting yourself from. Because I thought that one of the issues was that the people had a right to protect themselves from their own government. And that was one of the reasons that, you know, and that's why it happened in England and everything. So aren't the two tied together?
Sure. So, yeah, this is a really interesting question. And so the question is, just who is the militia referring to? Doesn't the Second Amendment give people the right to defend themselves against their government? Now, this is a point of scholarly contention. And there's one school of thought among scholars that says just that says what the Constitution is trying to do is actually set up a bloody arena where the people, by the Second Amendment, are armed, and Congress, with its Article I powers, can raise an army. And this would ensure that a mere rebellion representing a minority of the people would be put down by an army raised by Congress, but that a true revolution would actually be able to topple a tyrannical regime that had taken over the government. I wouldn't necessarily say that's a majority view among scholars, but there are well-respected legal scholars who take that very interpretation of the amendment.
One more question on the Second
Sure.
Amendment, then we'll move on.
Terrific.
Thank you. This is a little bit more simplistic. I want to know why they even mention militia if they weren't going to consider it for the militia as opposed to personal ownership?
Yeah, so this is a great question, and that is the fundamental point of people in the collective rights school that they point to. They say, why is there a discussion of a militia in this prefatory clause if it's not relating only to people in the militia? And so, you bring up a very valid point. And the best I can tell you is that people who support the individual rights gun ownership, they focus on other historical evidence, and the people who argue your side focus on precisely that clause. I mean, that's really the heart of the issue there. So we'll have time for more questions about all of these topics, but for now, I want to move on to yet another myth about the Constitution, this one concerning the First Amendment. Let me get, here we go. And specifically the Free Exercise Clause. We've talked about the Establishment Clause. Let's get into the Free Exercise Clause. The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, it is widely believed that this is the most important clause for protecting religious freedom, and specifically religious minorities. And I would argue that that's actually wrong, that there is a lesser-known clause in the Constitution that is actually far more important when it comes to religion, and I alluded to it briefly in the first half. Here's Article 6, Section 3. No religious test shall ever be required as a qualification to any office or public trust under the United States. Here is the Constitution spelling out in no uncertain terms that federal office will be open to everyone without regard to religious belief. Why is this clause more important than the First Amendment's free exercise? Why would a clause that only is relevant to people who want to run for federal office somehow be more important than a free exercise clause that applies to us all? Well, to address that question, we have to turn to the state constitutions. When America declared its independence from Britain, the colonies that were now states began drafting their own state constitutions. Here's a clause from the Pennsylvania Constitution of 1776. No authority shall in any case interfere with or in any manner control the right of conscience in the free exercise of religious worship. So the Pennsylvania Constitution at least pays lip service to the free exercise of faith. But consider this other clause from the Pennsylvania Constitution. And this concerns eligibility for office in the Pennsylvania legislature. Each member, before he takes his seat, shall make and subscribe the following declaration. I do acknowledge the scriptures of the Old and New Testament to be given by divine inspiration. In other words, only professing Christians could serve in a legislature. So as a state, you can say that you're providing free exercise, but is the exercise of faith truly free if you penalize religious dissenters for professing their religion? Let's look at the Georgia Constitution of 1777. All persons, whatever, shall have the free exercise of their religion. And here's the Georgia provision for eligibility for office. The representatives shall be chosen out of the residents of each county, and they shall be of the Protestant religion. You're not off the hook, New York. Here's the New York Constitution. The free exercise and enjoyment of religious profession and worship, without discrimination or preference, shall forever hereafter be allowed. Now, the New York Constitution also required Catholic immigrants to forswear allegiance to the Pope, not just politically, but also religiously. And New York had blue laws that required people of all faiths not to work on Sundays. So if you were Jewish in this era in New York, you couldn't work on Saturdays because of your religious tenets, and you couldn't work on Sundays because of the law. And so Jews could work 52 days a year less than their Christian counterparts, which adds up to 7 weeks of income annually. One particularly enlightened New York assemblyman at the time said that this amounted to effectively a tax just for being Jewish. In his words, this was not equal liberty, one of the boasted blessings of our government. But these words fell on deaf ears. In one state after the next, constitutions paid lip service to the principle of free exercise in theory while discriminating against religious minorities in practice. So in light of these state constitutions, the decision of the delegates at the Constitutional Convention to open federal office to those of all religious backgrounds was a radical advance for religious freedom. And not surprisingly, when the Constitution was sent to the states for ratification, this clause engendered a lot of resistance from those who were uncomfortable with the idea of religious minorities in office. At the Massachusetts ratifying convention, a delegate voiced exasperation that, quote, a Turk, a Jew, a Roman Catholic, and what is worse of all, a Universalist, may be President of the United States. Here in New York, a newspaper warned that the Constitution, quote, gives command of the whole militia to the president. Should he hereafter be a Jew, our whole posterity may be ordered to rebuild Jerusalem. And yet, despite this aversion among some to Jews, Catholics, Muslims, and other outgroups, the voices of enlightenment and tolerance won the day. And the U.S. Constitution, including its ban on religious tests, was ratified. If the state constitutions teach us anything, it's that abstract promises of the free exercise of religion don't mean much if you're then penalized for practicing your faith. The Constitution's clause banning religious tests for office gave substantive equality to religious minorities in an important realm of American civic life. Now, at the risk of wading into dangerous waters, I want to now discuss a constitutional topic that I think people of all political persuasions have a vested interest in better understanding: impeachment. What does the Constitution actually have to say about impeachment? Based on the facts that exist today in the public record, would an impeachment of Donald Trump be constitutional? Would it comport with the framers' vision, or would it be a violation of the constitutional text? To answer these questions, let's look at the text itself. Here's Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and high crimes and misdemeanors. And other high crimes and misdemeanors, thank you. So now it's important to read this not as high crimes and misdemeanors, but rather as high crimes and misdemeanors. A high misdemeanor was a legal category that has a different meaning than the way we use misdemeanor in modern legal parlance. A high misdemeanor in England at the time, for instance, included attempting to assassinate the king. So a high misdemeanor was a pretty serious crime. So there are two ways of interpreting the Constitution. One that would be favorable to those who want to see President Trump gone, and another that is favorable to President Trump. The first sees impeachment as part of the ordinary systems of checks and balances, that it is a political tool that Congress wields to oust a president who's doing their job particularly poorly, and that the language about crimes is not limited to just strict high criminality. And the other point of view is that impeachment is not part of the system of checks and balances, that it is not, in effect, a political tool like a congressional override of a presidential veto, that it is a strictly criminal proceeding reserved for the most egregious of crimes. So I want to lay out the strongest arguments on both sides for you. Now, the pro-democratic, anti-Trump interpretation of the Constitution says that impeachment is not limited to just a small category of high crimes. Let's look at what Hamilton says in Federalist 65. The practice of impeachments is a bridle in the hands of the legislative body upon the executive servants of the government. And keep in mind, impeachment is not just reserved for presidents. Other federal officers, like federal judges, can be impeached too. And Hamilton in Federalist 79 talks about what would occasion the impeachment of a judge. He says, they are liable to be impeached for malconduct by the House of Representatives and tried by the Senate. The key word here is malconduct. He's saying you can be kicked out if you do your job really badly, not mere criminality. Now, without question, the Hamiltonian school of thought would say, well, if the president commits a serious crime, that could occasion impeachment. But it's more expansive. Let me give you one more Hamilton quote from Federalist 65. A well-constituted court for the trial of impeachments has, under its jurisdiction, those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may, with peculiar propriety, be denominated political. And I did not capitalize political. Hamilton, in the original Federalist Papers, capitalized political, as they chiefly relate to injuries done immediately to society itself. Now, the threshold of 2/3 of the Senate that you need to actually remove a president who's been impeached by the House and then tried by the Senate ensures that there is a high bar to remove a president. So the way it works is the House, by a simple majority, would vote to impeach a president. They would draw up articles of impeachment, and then there would be representatives of the House who prosecute the president in the Senate, with the Senate sitting as a jury and the Chief Justice presiding. And so if we look at Hamilton's thoughts in the Federalist Papers, there seems to be a belief that impeachment is a political tool, that it is indeed part of our system of checks and balances. What are the best arguments in favor of Donald Trump? Well, let's look at another clause in the Constitution. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. Now, senators already take an oath to protect and defend the Constitution. Why would they need to take a second oath? Now, in criminal proceedings, jurors take oaths to render verdicts in accordance with the law and the evidence. There is no other part of the Constitution, no part of the systems and checks and balances where senators are required to take a second oath, only here. And so this would underscore the pro-Trump argument that impeachment is not part of the ordinary course of checks and balances, that it is strictly criminal. What else does the Constitution say that can shed light on this question? The trial of all crimes, except in cases of impeachment, shall be by jury. All crimes except impeachment. So clearly, impeachment concerns crimes. Otherwise, you wouldn't need this clause about impeachment, right? And keep in mind also that the highest-ranking judicial officer, the Chief Justice, presides at the trial in the Senate, underscoring the legalistic rather than political nature of the proceedings. Now, you might be thinking to yourself, Porwancher, if this was truly strictly criminal, how can we possibly make sense of what Hamilton had to say in the Federalist Papers, where he says it's political? Well, the argument that's been proposed by people like Alan Dershowitz recently is that Hamilton, by describing impeachment as political, is actually narrowing rather than expanding the grounds of impeachment. That Hamilton, knowing that the Constitution limits it to criminal causes, is saying that it has to be both high crime and a political offense. If a president has committed a high crime, but that crime isn't also a political offense, then it wouldn't warrant impeachment. Now, it's also worth noting that during the Constitutional Convention, not Madison actually, it was another delegate suggested that they put in the word maladministration. as the justification for impeachment. And Madison objects. And because of Madison's objection, they put in the phrase high crimes and misdemeanors, other high crimes and misdemeanors. And so this would underscore the notion that the framers had considered using impeachment as a political tool and rejected that idea. Now, the underlying philosophy behind that interpretation of the Constitution is that we should be wary of usurping the democratic process, that voters make a decision about whom to elect, and that decision may be wise or it may be foolish, but we would upset the democratic process by the Senate invalidating election results. That today the Senate may remove a president whom you loathe, but tomorrow they may kick out one that you love. And if impeachment really is a criminal proceeding, and a president hasn't clearly been guilty of a high crime, then to impeach him is to criminalize our political differences in a manner not befitting a democracy, but a banana republic. Now, the counter-argument to that is that we're not supposed to be a democracy, that the framers set up a republic, that voters don't get to decide everything, that we have representatives whom we send to Congress. And these representatives take an oath, not to us, but to the Constitution. And for the Congress to fail to impeach a president who should be impeached is a dereliction of their duty and a betrayal to their oath to the Constitution. Let me raise some questions about the kind of uncharted territory we may find ourselves in should Democrats take control of the House and impeach President Trump. Now, some of these questions you've probably already heard, and some of them may be new. Ones that have been commonly proposed in the media are, is a president's pardon power unlimited? Can a president pardon himself? Does a president have a free hand to fire anyone in his executive branch without cause? And if there is evidence that Donald Trump colluded with Russia, is collusion actually a crime? What about the emoluments clause? Does emoluments only pertain to gifts from foreign sovereigns? Or does it also apply to payment for services rendered? If a diplomat stays at a Trump hotel and pays for the room, is the fee for that room an emolument under the terms of the Constitution? We don't have clear answers to these questions because courts haven't had to rule on this. Let me add some more questions to this list, questions that you may not have thought of, but questions that may well throw our country into a constitutional crisis of unprecedented scope. Now, in a criminal proceeding, a defendant has the right to challenge the indictment against them. And they can ask the judge to throw out the charges if they feel that the charges are based on frivolous grounds. And a judge can do that without it even going to trial. Now, if impeachment really is a criminal proceeding, then when we get to the trial stage in the Senate, in theory, President Trump's lawyers should be able to ask Chief Justice John Roberts to dismiss the articles of impeachment. And if he were to do so, who's to say that the Senate would abide by that? And if the Senate refused to abide, could that issue then be litigated in front of the full 9-member Supreme Court? Now, all of these hypothetical questions that have been raised in this unusual moment in our political history have yet to be resolved. And I wish I could tell you definitively what the framers thought about all of these issues. But they did not endeavor to try to anticipate and preemptively remedy every possible constitutional dilemma that could ever arise. I'm reminded of the words of George Washington, who was mindful of the fact that he was drawing on a blank slate, that as the nation's first president, he would set precedents that would inform future generations. Washington famously said, "I walk on untrodden ground." Here we are in 2018, more than 2 centuries later, and we're still walking on untrodden ground. Now, I've referred back to the Federalist Papers a number of times today, and I promised our viewers in Virginia I would take Hamilton down a peg, much as it pains me as a Hamilton biographer. But that time has come. Now, the Federalist Papers weren't actually that important in their own historical moment. There is little evidence that they had any real effect on the needle of public opinion. They were written to try to persuade New Yorkers to vote Federalists rather than anti-Federalists to the state ratifying convention in Poughkeepsie. Instead, by a 2-to-1 margin, New Yorkers chose anti-Federalists to serve at the state convention. The Federalist Papers became hugely significant later on only as a tool with which to interpret the Constitution in future generations. Now, we've talked about church and state, establishment, free exercise, the Second Amendment, impeachment, and the questions around these issues are really different versions of the same question, which is, what was the framers' original intent? Well, sometimes we can speak coherently about the framers' original intent, but sometimes we can't, because the framers disagreed with each other or because the historical record is too sparse. Take, for example, the issue of the first Bank of the United States. In the early days of the Washington administration, Hamilton proposed to Congress that it start a bank. Now, does Congress actually have the power to start a bank? This was the question occasioned by this debate. Now, let's look at the text of Article 1, Section 8. Right? Now, in Article 1, Congress has a bunch of enumerated powers. Right? It can declare war, can start a post office, and many of those enumerated powers concern money. It can coin money. It can borrow money. Congress can regulate commerce between the states. Then we have this clause. The Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Well, a Bank of the United States could certainly be conducive towards Congress fulfilling its enumerated powers, but is it actually necessary? Well, James Madison, who was at the Constitutional Convention, says no. The Constitution does not allow you to do that. A bank could be helpful, but it's not necessary, and so it is outside the boundaries of our authority. Well, Alexander Hamilton, who was also at the Constitutional Convention, said, James, you're wrong. The delegates never intended to debilitate the federal government with an unduly restrictive reading of the necessary and proper clause. Here's what Hamilton writes to Washington, as Washington's considering whether to veto the bank bill or not. Hamilton says, necessary often means no more than needful, requisite, incidental, useful, or conducive to. In the end, Hamilton convinced Congress and Washington that the bank was indeed constitutional. But my broader point, or really my broader question, is how do we speak of the framers' intent on the necessary and proper clause when the people who were, to quote Lin-Manuel Miranda, in the room where it happened, actually could not agree on what the word necessary means? Well, some proponents of originalism would counter the intent of the framers doesn't really matter, right? The Constitution, as they wrote it, was just ink and parchment. It was the state ratifying conventions that gave the Constitution legal force. And so when interpreting the Constitution today, we should go back to the proceedings of the state ratifying conventions. And there are other originalists who say, actually, it's the original public meaning. What was the generally understood meaning of the words of the Constitution? And they'll look to dictionaries. And here again, I would say that there are some clauses where we can discern a coherent and intelligible, monolithic original intent, but not for every clause does the historical record provide us the guidance we seek. Now, the question of whether originalism is desirable is a distinct question from whether it's possible. When the original intent is knowable and coherent, should we follow it? Well, I think it's important to acknowledge that originalism isn't always an option. I think we should also be wary of assuming that there is no wisdom to be gleaned from the founding generation. The founders had to create a government from scratch. We've inherited one. They had to think more deeply than our modern day political leadership about the enduring principles of governance and statecraft in a way that I would argue we don't always see from political leadership on either side of the aisle. And we may ignore the wisdom of the framers at our own peril. So where does all of this discussion leave us? What are we to make of the U.S. Constitution with its contradictions, its nuances, its ambiguities? We have an establishment clause that could mandate the separation of church and state, or not. We have a Second Amendment that could provide for an individual right to gun ownership, or not. We have an impeachment clause that could justify the ouster of President Trump, or not. By now, some of you are thinking, poor Wancher, I came here for answers. What kind of a scam are you running? Let me suggest to you a different way of thinking about the Constitution. Naturally, we want it to provide answers. We want it to give us clear guidance. We want it to remedy our dilemmas. But I would argue that if we focus on the inability of the Constitution to resolve our debates for us, we miss the forest for the trees. I submit to you that the point of our Constitution is not to resolve our debates. It is to provide legislative halls and courtrooms where these heated debates can continue. What the founders understood was that when debate ends, violence begins. When people stop yelling at each other, they start firing at one another. The founders knew, even back in 1787, that America was too large and too diverse for there to be much unanimity about anything. The politics of their day were as fractured and toxic as our own. They suffered no illusions that Americans would somehow harmonize around a single governing philosophy. The Constitution that they bequeathed to us furnishes us with political and legal arenas where we can continue to have heated disagreements because the alternative is bloodshed. They had lived through a war, and they knew firsthand that when politics breaks down, carnage ensues. And so they crafted a constitution not to resolve our debates, but rather to keep them going. We may lament the state of our politics in 2018. We have two parties wherein each believes that when the other comes to power, they will destroy America from the inside out. Well, that's what the Federalists and Anti-Federalists believed about each other. That's what Hamilton and Jefferson believed about one another. We have always disagreed on the proper relationship between the state and its citizens, and we probably always will. But so long as the debate continues, the Constitution succeeds. We are a young country. We just celebrated our 242nd birthday. We are centuries and even millennia younger than other societies around the world, and yet no other country on earth has a constitution in effect today that has been in continuous use longer than ours. Its longevity is the greatest testament to its extraordinary success, not in resolving our debates, but in institutionalizing them. At the close of the Constitutional Convention, Benjamin Franklin, who had an honorary doctorate from Oxford, was leaving the Pennsylvania State House for the final time, and a woman came up to him and asked, "Well, doctor, what have we got? A republic or a monarchy?" Franklin famously replied, "A republic, if you can keep it." Today, more than 2 centuries since Franklin issued this challenge, the Constitution endures, the republic abides, and the debate lives on. Thank you.
Who coined the word democracy? We have a constitutional republic. Why does everybody call it a democracy? It's not.
Yeah, the question is, why do we call America democracy when it's not? We have a constitutional republic. I think that's a fair question. There's a certain pessimism among the founders about, and it's particularly people like Hamilton, I have to admit, about mass rule, about rule by the people. They feared mob rule, and they They wanted the will of the people to be expressed in the government, but they wanted it to be mediated through institutions. And they also understood the importance of counter-majoritarian liberties. The rights in the First Amendment, things that we've talked about, like free exercise, are about protecting individuals from democratic majorities. And so I take your point. I think it's a fair question. And I'll go wherever the microphone goes.
Okay.
So
Up here in the corner?
I'll follow you.
Real quick, going back to the Second Amendment, you said there was really no debate about it, but Madison had original text that was eliminated. Can you explain that dynamic? Why was that text eliminated if they weren't debating the Second Amendment?
Right. So it wasn't that. Let me clarify my wording. It's not that there was no discussion of it at all. As you noted, that clause was taken out, but there wasn't a debate, at least that we have copious records of, that would definitively answer for us whether the framers intended for it to have an individual or a collective meaning. And one of the challenges in terms of these records is that Madison himself kept notes of the Constitutional Convention, but he then revised those notes later to meet later political needs that he had. And so we have to be wary by going on Madison alone. And Hamilton biographers are always a little bit skeptical of Madison, so you can take that with a grain of salt. The next question. Yes?
Did the founding fathers trust the vote of the people given the establishment of the Electoral College?
Yeah, so the question is, did the founders trust the people given the Electoral College? I would argue, I think it's a great question. The Electoral College is one of the best examples of the founders' distrust in the masses. And it was not necessary, there's nothing in the Constitution that requires that votes, that there be a popular vote in each state. They could have had the state legislatures just say, okay, we're going to choose this person for president. In fact, in New York, in the election of 1800, it was the New York State Legislature that cast New York's tie-breaking votes that gave the election to Jefferson over John Adams in 1800. And so there's nothing really that democratic about the Electoral College. It's more democratic than it used to be, but it's certainly less democratic than just a national popular vote. So thank you for your question. Yes, sir.
Hi. A narrow question on the Second Amendment. Was there any discussion about different kinds of arms? There's a difference between people keeping muskets and people keeping cannon, for example. Was there any of that sort of discussion?
In the records that I've seen, I have not seen them distinguish between, say, cannons and muskets. There are records from colonial America where because there was a lot of concern about fighting between colonists and Native Americans. And so they were concerned about people maintaining arms so they could defend their plantations. Keep in mind, the vast majority of the people are living in a rural countryside. You can't just call 911, right? And so it was important for people's protection that they have arms. And so there wasn't, I haven't seen records distinguishing between firearms. And I think that today we have a range of firearms and there's a lethality to some of our firearms that are far beyond anything they could have imagined. But thank you for your question. Yes, ma'am.
You mentioned the Heller decision.
Yes.
Was that the first time that militias were equated with individuals?
So the question is about the D.C. versus Heller decision in 2008. And the question is this the first time the Supreme Court said that there's an individual right to bear arms? And the answer is yes. Believe it or not, 2008 is the first time that the Supreme Court ever had to rule on this issue. And because the case had to do with the District of Columbia, it only applied to D.C. And so it's 2 years later, we get another case from Chicago where the Supreme Court says, yes, actually the Second Amendment applies to states too, not just this weird federal district that we have that's sort of not a state but also not part of the country.
Hi.
Yes.
Yes. You said something that really interests me. I want to explore it further, that our representatives are elected to uphold the Constitution and not necessarily to represent us. Is that a nuance, or could you explain that?
Sure. Well, what I would say is that not necessarily that they're elected for that end, but they take an oath to the Constitution. And so if their duty is ultimately to their oath, then that's where their legal obligations lie. And so, for instance, let's say that you're a member of Congress and you have access to intelligence from the CIA that your constituents don't have, and your constituents don't want you to vote to go to war, but you're privileged with knowledge that they don't have. You know, I think there's an argument to be made that you have an obligation in your duty and in your oath to the Constitution to actually go against the wishes of your constituents, that may be the price of leadership. Yes, sir.
Given the unique nature of the country's, the idea of federalism and the division of powers rather than the separation of powers, does the Constitution avoid the conflation between state sovereignty, which seems to have been resolved in the Civil War, and states' rights, which is still an ongoing, vibrant issue?
Yeah, so I think the Constitution did not resolve that debate. On the one hand, the Constitution has a clause that says this Constitution is the supreme law of the land, that everything else is subordinate. Now, there's also an amendment to the Constitution in the original Bill of Rights that says rights that aren't given to this government are reserved for the states and the people. And so this set up a conflict. And before the Civil War, there's an argument made by people like Jefferson who say states can nullify actions from the federal government. And so ultimately, it wasn't the Constitution, but rather a civil war that determined once and for all which interpretation of the Constitution would rule out. And the issue of federalism continues to be a live one, and I think always will be. Yes, ma'am.
So what happens, is it on? I can't tell. Okay. What happens when an individual's right to the free exercise of religion pushes back against a right, due process or equal protection under the law and the 14th Amendment? Who supersedes what? I mean,
Yeah,
how is that settled?
So you're asking about the free exercise of religion?
Pushing back against equal protection under the law.
Right. So the question is, how are we to consider when someone's free exercise rights run up against someone else's due process or equal protection rights? There's a line in judicial reasoning about how my right to swing my fist ends when it hits your face, right? And so I think that it's often the case that rights come up against each other, right? The individual right to liberty and national security often come in tension with each other. And so what courts will often do is say, okay, we have two fundamental liberties at stake, and we're going to employ a balancing test. And we're going to weigh these two rights in the balance. And so there really is no one right that trumps every other right in the Constitution, right? There's a famous aphorism from Oliver Wendell Holmes that you cannot shout fire in a crowded theater, right? And so even though you have freedom of speech, that can still be curtailed. And so there is no right that's absolute, and the way judges have dealt with this is just balancing tests. So thank you for your question. Yes, ma'am.
Mention of the Electoral College reminded me, where did that come from and when?
Well, so the Electoral College is written into the text of the Constitution. So this is something the framers came up with as a way, and bigger states like this, because your electoral votes are the number of senators you have plus the number of representatives you have in the House. And so that was from the inception, the Electoral College. And the last thing I'll mention about the Electoral College is there's nothing in the Constitution that requires every state's electoral votes to just go to one candidate. That was something states did to make themselves more relevant, but now they're trapped in this prisoner's dilemma where if any one of them gave it up, it would hurt the political party that's favored there, so none of them give it up. And so states like New York and Texas get ignored in the general election. Yes, sir.
I recently attended a forum in New York about the Supreme Court, and I don't recall the woman's name, but you'll know who she is. She's the one that tried the case about gay marriage and so on. And
She's done like 41 cases against the Supreme, argued for the Supreme, with the Supreme Court. And she started to cry because of the way the courts changed. Yeah, so my question simply is that the way the Constitution appears to be written, it's so ambiguous in so many areas that it's almost nullified. It can go one way or another.
Yeah, so, you know, I think, so the question is about how do we adjudicate the Constitution with areas of ambiguity? And so not all parts of the Constitution are ambiguous. We know, for instance, that you have to be 35 to be eligible to be president. Some parts of it are crystal clear. Other parts of it, like some that we've discussed today, are ambiguous. Justice Cardozo, which is a name that might be familiar to New Yorkers, said, well, when we don't have a clear intent, you know, we rely on a few other things. One is precedent. One is sociology. What would be the outcome in society if we rule in this direction versus that direction? And the other would be history. What are the lessons of history that we can use to adjudicate? And so judges have at various times used different tools to try to draw meaning from the Constitution in a way that's going to make sense in that time and place. So thanks for your question. Yes?
Here. You gave a couple of examples recently. You mentioned about the power of your fist enter someone's face, and the other thing about a burning building where you can't. How did it become the case that every right that's given to us by the Constitution has its limits, except the right to bear arms?
Well, so this is, so you know what I would say is you know, that question I think is going to have a more coherent, so the question is, it seems like every right has its limits except the right to bear arms. The truth is, relative to other areas of the Constitution, Second Amendment jurisprudence is really undeveloped, right? We really just have a couple big Supreme Court cases versus the dozens and dozens we have in things like church and state and free exercise. And so I think, you know, the court left it open to states and municipalities to regulate guns, have those regulations challenged in court, and then the court can decide later whether these regulations fall within the scope. And so one of the things that the conservative majority says in its existing case law is that, for instance, it should be okay for schools to regulate guns. Students shouldn't be able to bring guns into a high school. That would pass constitutional muster. But we don't really know because it's such a new area of law, believe it or not, that we just have very few decisions. And so I think in 20 or 30 or 40 years, we're going to be able to answer that question more coherently. And we'll be doing a one-day university event on that in 2038, and I encourage you all to come.
There's a question which came in from the group watching at Atria in Connecticut.
Very cool.
And I'm trying to figure, basically they're asking, besides the Second Amendment, are there any parts of the Constitution that you believe a huge number of Americans are interpreting incorrectly or not the way they were written?
Or not the way they were written. You know, so the question is, are there other parts of the Constitution that are being interpreted in ways that are different from the way they were intended? So I think search and seizure jurisprudence is an area of constitutional law. The Fourth Amendment says the government can't search and seize you without having a warrant, right? Well, this was written at a time before they had computers, right? And so if the government can, you know, take information without actually going into your house digitally, is that a violation of the Fourth Amendment? Or what if the police put a little bug under your car and they're able to track your car for 30 days and track all of your movements in a way that a policeman wouldn't be able to keep up with you on all of those turns? Because you're all fast drivers, I'm sure, as New Yorkers, right? So I think that search and seizure jurisprudence, it's almost impossible for us to interpret it in a way that's consistent with the framers' vision because the pace of technology changes so quickly that it eludes our ability. And we always see law always lags behind technological advance. So I think the Fourth Amendment is a particularly ripe area where we can be led astray.
Okay.
And we have another question?
From Austin, Texas.
Great.
They asked about the Fifth Amendment, which
Yes.
they think, as far as they know, does not exist in many other countries at all. Where did that come from? Is there any legislative history on it?
Sure. So the Fifth Amendment gives us due process. So a lot of the protections you have if you're accused of a crime come from the Fifth Amendment. And there was a history in the British colonial experience of protecting people's rights. And one of the concerns about the colonists, you asked about the history of it, one of the concerns of the colonists is they said, well, we like the British legal tradition, we like these protections, and the British are forsaking it, because the British started prosecuting American smugglers in colonial times, not in American courts, but they would bring them to British courts, or they would try them in these special admiralty courts. And so when the Americans created the Constitution and created the Bill of Rights, they said, we want to bring back the pieces of the British legal system that we like. And so, for instance, presumption of innocence is not actually, the words of that aren't in the Constitution, but it's understood to be part of a whole culture of legal protections that adhere in the Due Process Clause. So, and I thank Austin for that question.
All right, let's do this one last question there. There's one
Okay.
from Sacramento saying, don't you know what time it is? You started at 7 a.m. But I don't think you need to answer that.
Okay.
Let's do one last question here, sir.
Thank you. Louis Brandeis famously said that we could either have wealth concentrated in the hands of fewer and fewer people, an oligarchy or a plutocracy, or we could have a democracy, but we can't have both. Do you think recent Supreme Court decisions like Citizens United has undermined and subverted our democracy?
Okay, so the question is, has Citizens United undermined and subverted our democracy? So so one of the things as a historian you got to do is describe history without having to take these positions. But you're putting me on the spot, so I'll answer your question. So I think Citizens United makes a lot of sense in the abstract and is problematic in practice. And so, for instance, let's say you and I both have free speech, and you have your voice, and you're out there on a street corner, right? And I have a megaphone that's 1 billion times louder than your voice, and I'm speaking so loudly in it that I can drown out everything you say. Is that the equivalent of a billionaire being able to use their money to advocate for their particular views? I think that it is. Now, on the other hand, it can be very problematic to have the government, because if you say, well, we're going to limit speech, right, or we're going to limit the amount of funding that can be spent on speech, someone has to be empowered to do that, and that's the government. And you may not always trust the people who are in charge of the government. Usually, a lot of the people who are the most upset with Citizens United wouldn't necessarily trust the current administration and Congress to legislate in a way that would protect your speech freedoms. And so I think the answer to this is to have total separation between campaigns and any kind of independent organizations. And technically that's supposed to be the case, but there's no enforcement of this. There is total collusion that the government just lets happen between political campaigns and super PACs. And there's also no transparency. We need to know where the money is coming from. And so I think there needs to be a change. I think Citizens United will be overturned. I think it'll happen in my lifetime, but I don't think we're going to see it anytime soon. But thank you for your questions. Thank you, New York. Thank you to everyone tuning in around the country. And thank you, One Day University.
Again, to those of you in the audience, thank you for coming. To those of you around the country, if you're